In this lesson, we will talk about procedural safeguards, cross-border coordination, and recent enforcement and sanctions regimes, 2023-2026. The global sanctions landscape is defined by robust procedural safeguards, expanding cross-border enforcement mechanisms, and high-profile enforcement actions. Effective compliance requires understanding legal remedies, due process, and the operational realities of asset freezing and international cooperation. The table of contents outlines the legal and procedural safeguards related to sanctions, asset freezing, and export control investigations across the United States, OFAC United Kingdom, SAMLA 2018, and European Union, CG Article 263 TFU. It also highlights cross-border coordination mechanisms, such as the OFAC MO 2024 and EU Regulation 2018-1805, alongside other multilateral efforts. A review of recent enforcement actions, 2023-2026, includes notable U.S. cases and UK asset freezes, followed by comparative tables summarizing key frameworks and a conclusion. In the first section about procedural safeguards and due process, let's start our analysis with United States OFAC. First step is the delisting petition process. Designated parties can submit a written petition to OFAC to request removal from the Specially Designated Nationals (SDN) or other sanctions lists. The petition must include supporting evidence such as legal arguments, compliance records, or policy justifications to demonstrate why the designation is no longer valid or necessary. OFAC reviews the petition, may request additional information, and issues a written decision. While there is no statutory deadline for a response, petitioners can submit further evidence if denied or seek judicial review. Judicial review: if a delisting petition is denied, parties can challenge OFAC's decision in federal court under the Administrative Procedure Act (APA). Courts evaluate whether OFAC's actions were arbitrary, capricious, and abuse of discretion, or otherwise not in accordance with law. While courts generally defer to OFAC's expertise, they require a rational connection between the evidence and the designation. This ensures that OFAC's decisions are legally and procedurally sound. Humanitarian licenses: OFAC provides general licenses for broad categories like food, medicine, and NGO activities, as well as specific licenses for case-by-case needs, such as legal fees or urgent humanitarian assistance. Applications for specific licenses are submitted through OFAC's online portal, and urgent requests may be expedited. These licenses ensure that humanitarian needs are met while maintaining compliance with sanctions regulations. Due process protections: OFAC ensures due process by providing public notice of designations via the Federal Register and its website, as well as direct notification for blocked property. Designated parties may receive a summary of reasons and unclassified evidence supporting their designation, though classified information may be withheld. Parties have the right to legal counsel, and blocked funds may be licensed for legal fees. Administrative review precedes judicial review, ensuring multiple layers of procedural safeguards. The next country to analyze is the United Kingdom, SAMLA 2018. Challenging designations: designated individuals are promptly notified with a statement of reasons for their designation. They may request an administrative review by the minister to reconsider the decision. If unsatisfied, they can apply for judicial review under Section 38 of SAMLA 2018 in the High Court or Court of Session in Scotland. The court evaluates the designation's lawfulness, rationality, and procedural fairness, and may quash it if the statutory test is not met. Transparency and oversight: all designations are published in the UK sanctions list, ensuring public visibility. Parliament provides oversight by scrutinizing new sanctions regulations, maintaining transparency in the sanctions process, and ensuring accountability for government actions. Humanitarian licenses: the Office of Financial Sanctions Implementation, OFSI, issues general and specific licenses for humanitarian purposes, such as access to food, medicine, or other basic needs. Applications are prioritized in cases of genuine humanitarian need, or where there is a direct risk to life, ensuring urgent cases are addressed promptly. Notable precedents: the Senesis 2022 case clarified evidentiary standards required for sanctions designations, while the Scheck-Schwidler 2023 case highlighted the importance of proportionality and the cumulative effect of sanctions, reinforcing fairness and balance in the application of sanctions. In the next lesson, we will talk about the European Union's procedural safeguards and due process. Also, we will analyze the cross-border coordination mechanisms, and particularly OFAC MO 2024, EU Regulation 2018-1805, and other multilateral mechanisms.